Okay, I think we can get started. So hello, everyone, and thank you all for joining us for today's webinar. I'm Alice Yerk. I'll be giving a more robust introduction of myself, as will my colleagues, David Kornblau and Walter Van Dorn. But before we do that, we have a few housekeeping notes for you today. So for the benefit of all participants in this webinar, we have muted the attendee lines. If you have any questions that you would like to submit during the event, we would ask you to submit them through the question and answer space. If we can't address your question during today's webinar, we will follow up with you after this program. Please note that today's webinar will be recorded and circulated to all registrants via email after this event. If you have follow-up questions at that time, please reach out to any of the key contacts listed in your email communication. Note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or a laptop device. Credit is not available for joining via a mobile device. So one other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in those states, you can disregard this. So without further ado, I'll just give you a brief summary that today we will be discussing current and future trends in digital asset regulation and enforcement. And we'll talk about the driving forces behind digital asset regulation in the US with a particular emphasis on the securities and commodities laws and the enforcement of those particular laws. I'm Alice Yerk. I'm a partner at Dentons in New York in the capital market space with a specialty in derivatives, structured products, commodities, and cryptocurrency regulation as those laws pertain to that area. So Walter, would you like to give a brief introduction followed by David?
Sure. Thank you all for joining. It's a pleasure to be able to speak to you. As Alice said, I'm Walter Van Dorn. I'm a capital markets lawyer here at Dentons, also in the New York office, and I specialize in securities law and securities regulations, in part because I worked at the SEC myself for a number of years earlier in my career, and I continue to do that kind of work here at Dentons.
Thank you. David?
Hi, everyone. I'm David Kornblau. I am co-chair for the U.S. region of the firm's global compliance and investigations practice. I was formerly the head of litigation in the SEC enforcement division. And for over 20 years, I've defended clients in complex and sensitive investigations by the SEC and other law enforcement agencies. And in recent years, quite a few of those clients have been in the crypto industry, and I'm happy to give folks an overview in that area a little later in the presentation.
Thank you both very much. So let's start our discussion by first presenting the regulatory landscape, both in terms of how it exists or what it looks like now and what it's likely to look like in the near future. So Walter, could you start us off by talking a bit about the securities laws aspects, and then I'll jump in later to talk about the commodities laws.
Sure, Alice, I'm glad to do that, and I'll get started. So I think, the biggest issue with any sort of new technology, which certainly includes, the crypto assets and tokens and the like, is, what are these things and how and by whom are they regulated? And that's an issue that regulators, the government, and lawyers have been grappling with for the last, I guess 6 or 7 years since this became popular. So the main focus we look at from the securities perspective, which is what I'm going to address, is whether the asset or the cryptographic token or whatever you have in question would be considered a security under the U.S. securities laws. Perhaps to restate the obvious, but the asset would only be regulated under the securities laws if in fact it is considered a security in the first place. And what has become clear, and perhaps always should have been clear, is that specific terminology used is not all that important. So the fact that the asset is not referred to as a security is far from being determinative. So the principal laws in our country regulate something that is considered a security are first and foremost the Securities Act of 1933, the Securities Exchange Act of 1934, the Investment Company Act of 1940, and the Investment Advisors Act of 1940. So as I mentioned, if the asset or the token in question is considered a security, there are going to be a number of important regulatory consequences from that determination. First and foremost, any transaction involving an asset which is considered a security is going to be regulated by the principal regulator in the U.S. markets of the securities industry and of securities, the Securities and Exchange Commission, or SEC. Right from the get-go, any offer and sale of a token or any other crypto asset that is considered a security is required to be registered with the SEC, or it has to be subject to some exemption from that registration requirements. This is no different from any other sale, offer and sale of stocks or bonds in the U.S. market. If you are offering or selling stocks and bonds in the United States to another person, that transaction needs SEC registration in advance, or you have to have some exemption from that requirement, such as, for example, a private placement. And if your asset is, your token is considered a security, then those rules apply. This came up frequently when the market first became popular, probably 2017, when many people remember ICOs rather than IPOs were a popular thing. And the SEC clamped down on that pretty quickly, saying these so-called ICOs are in fact no different than IPOs, even though you're using a different acronym, and they still have to go through the same SEC registration process or have an SEC exemption, just like any other more conventional IPO would. Okay, so that's the first step you get to. Secondly, secondary trading is also in securities in this country is also regulated and has been for many years. And again, it's no different than anything else if the token or other asset in question is considered a security. In this case, the regulation is under our Securities Exchange Act rather than under our Securities Act. Another important point to keep in mind, and I've been actually saying this both to clients and in these presentations for the last 5 or 6 years, is that while most attention is devoted to the initial offer of a security, such as through an IPO or an ICO, other participants in other stages in the distribution and trading process are also very important and just as much regulated. These include offering participants like broker-dealers, investment advisors, transfer agents, and custodians. Importantly, it also includes stock exchanges. This has just been brought to the fore literally in the past week or two. This is something I believe David is going to talk about when he gets into the details of the enforcement landscape later on in the presentation with the, for example, Binance and Coinbase actions that have recently been filed. Those were important, not only because they're quite prominent, and not only do they talk about the securities offering process and trading process that I've been mentioning, but those actions are also very important because they go on in some detail to address other intermediaries or participants. They've talked about the broker-dealer requirements, the transfer agency requirements, the custodian requirements, and importantly, they also mention the question of whether stock exchanges or other portals or other systems trading tokens that end up being securities are also themselves stock exchanges that need to be registered, and they conclude, not surprisingly, that they are. So an important fact to remember is any sort of internet portal or other mechanisms for creating and facilitating secondary trades of items or assets that end up being considered securities are very likely to come under the SEC definition of a stock exchange and also need to be regulated as a stock exchange. Finally, another aspect that's important not to neglect is the fund industry. Any fund that owns a substantial amount of assets which are some sort of crypto token that are considered securities very likely will need to be registered itself as an investment company, just like any sort of more normal mutual fund would need to be registered. one of the principal ways in assessing whether a given fund or sort of hedge fund or anything like that is a type of a fund that requires SEC registration, just in the way a mutual fund would be, is by looking at the composition of the assets of that entity. Generally speaking, if at least 40% of the assets are made up of assets which are considered securities, then the entity itself is considered an investment company and requires registration under the Investment Company Act, and any advisor that advises the entity as to the composition of its assets would be deemed an investment advisor, which needs to be registered to the SEC under the Investment Advisors Act. Okay, so I've now sort of quickly outlined all the different consequences of what happens if your asset, such as your token, would be considered a security. Then we get to the real important question, right? How do you know whether or not it's a security? Well, first of all, there's a statute that talks about it, which is good, although it doesn't always answer the questions. And then there's a variety of decisions of courts that have also interpreted the statute. And there are two that I'll talk about in particular that are quite important. One is the Howey case and another is the Gary Plastic case. But first of all, let's get back to the statute itself. Section 2 of the Securities Act of 1933, which, as I said, is our primary statute regulating the securities industry, gives a definition of a security. Can we move a couple of slides ahead? I apologize. Let's go one more and one more. There you go. Thank you. This is a very long, sort of meandering definition, and you don't have to read it all in detail, but suffice it to say, it doesn't always help in the real world. It's a bit archaic at times and is not always useful. But of the laundry list of items here in the statute, which are considered securities, I've underlined one in particular, and that is the term investment contract. So as a result of this, the meaning of an investment contract really has ended up being the key to determining whether the crypto assets in question would be a security. So the most important Supreme Court case, which actually is quite old and sort of ironic considering these are such new and novel assets, is a 1946 Supreme Court case that determines or interprets what is an investment contract, but so be it. That is the case that's sort of the law of the land and still the guiding and controlling case on whether or not something is an investment contract, which in turn, under this section of the statute, is a security. Can we get the next slide, please? Okay, so as I said, the Supreme Court on the Howey case assessed whether or not a certain asset would be an investment contract and therefore a security. And a particular test evolved from this case, which we refer to frequently now as the Howey test. And many of you may have heard this term thrown around, especially in the crypto context, although it's been around for, again, whatever it is now, 80 years almost. Anyway, the test looks at four things to determine whether you have an investment contract. Has there been an investment of money? Has the investment been in a common enterprise? Was the investment made with a reasonable expectation of profits? And were those profits to be derived from the entrepreneurial, or managerial efforts of someone else? And it's this test, which to this day, the SEC and courts are still using to determine whether crypto assets could be an investment contract, which are securities. Can we get the next slide, please? So I think it's worth spending a minute on this because it's so important. So as I said, there's four parts to the test. The first two, is there an investment of money and is there a common enterprise, are virtually always satisfied and are really rarely in dispute. So I don't think we need to worry too much about those. I will say, by the way, with investment of money, it doesn't necessarily have to be cash or fiat currency, but it could be really any asset or anything of value you invest in the enterprise. And the enterprise needs to be a common enterprise. In other words, a group enterprise with people coming together to do something. I would also go on to say that the expectation of profit, the third prong, is also usually less controversial because typically there is an expectation of profit. Although in not all cases where somebody expects a profit from what they're doing, is there a security? A good example could be, baseball cards, antiques, rare artworks, real estate. In many of those cases, people who purchase these things expect a profit from holding them, although profit isn't always a security. And the reason for that, and it leads us to the fourth part of the test, which is usually the most hotly contested part and the most important part of this 4-part test. That is, the expectation of profits needs to be from the entrepreneurial or managerial efforts of others, the fourth prong of the Howey test. And this is really where, I guess, as they say, the rubber hits the road. So if you're providing your money to other people, to someone else, and you're relying on their efforts to earn the profit for you, then what you're doing is almost certainly going to be an investment contract and will be a security. So for example, use a more obvious non-crypto case. If you invest your money in, let's say, Tesla, you probably think Elon Musk is going to do great things. He and his employees at his company are going to earn money by their knowledge, their efforts, their skills, and you're going to get a return on your investment. Nobody would really doubt that. When you buy a stock or a bond in any company, it's because you assume the management of that company is going to do things that are successful and earn you a profit. So the question here with a token and the other sort of crypto asset, when you pay fiat currency, you get back a token. Do you expect the management or the sponsors of this enterprise are going to earn a profit for you, are going to do things, I guess you should say, with your money that are going to earn a profit? This area, by the way, is important to note, where the concept of decentralization often comes in. Frequently in these enterprises, people will say, well, it's really decentralized. There's no particular management. There's no brains behind the operation. All the participants are collectively doing it on their own. For example, there's no Bill Gates behind Microsoft. There's no Elon Musk behind Tesla. Rather, it's all the users collectively joining hand in hand in a decentralized manner and running the enterprise. If that's the case, it very well may not be an investment contract, or it may not be a security, because there are a number of enterprises where, as I understand it, the business is completely decentralized and sort of, I guess, runs on its own power, for lack of a better word, and you're not depending on some management or manager behind the scenes. And if that's the case, it may well not be a security, but this is usually what's in dispute. Can we get the next slide, please? Another Supreme Court case you hear about periodically, and again, I'll mention the name, not because we're going to quiz you on all these things, but because these are a couple of names you will hear about if you're following this industry. One, Howey, we just finished talking about, and now Gary Plastic. Gary Plastic is somewhat of a different analysis of the Supreme Court. I'm sorry, the courts have also used to determine whether a security exists. And this really relies on a somewhat different concept, and that is where the sponsor or the founder of the enterprise in question has taken an asset that on its face might not be deemed a security or an investment contract or anything like that, but has created a very liquid, tradable item which can be traded for profits and basically turned into a security. It's a lesser used test, I would say, much less frequently used than Howey, but it's still important and still one that courts and others do look at. In the case of Gary Plastic, this is relatively old, but not quite as old as Howey. The sponsors had an enterprise in which they took bank issued CDs, which are generally not considered securities in and of themselves, and certificated them and put them in a format that could be traded over in stock exchanges on the secondary markets. And the court there found that even though the bank CD in the absolute sense probably is not a security, in the manner in which it was transformed and reformulated into a tradable asset was in fact a security. And this same analysis often is also applied to the crypto asset. So basically, to summarize what I've been talking about, the first test to determine whether the securities regulatory regime applies is your asset in question a security? If so, there's a number of SEC rules that will apply to it, not only the initial offer and sale, but also to intermediaries and secondary trading and trading mechanisms, which could be deemed stock exchanges. The primary way that people look at these to determine whether or not the asset is a security is the Howey test, which basically has a 4-part test. Is there an investment of money in a common enterprise in which the would-be investor seeks a profit on the investment based on the efforts of others? So with that, I will hand it over to Alice, who's going to focus on the CFTC aspects of these things.
Thank you very much, Walter. Yes, thank you. And if we can move to the following slide, that would be great. So I think it's useful in the context of the commodities laws to understand a bit of the background of the commodities laws. And historically, what I should start with is a note that the Commodity Futures Trading Commission, which is the chief regulator charged with oversight over the commodities markets, has had its principal oversight over futures. And that was true for the longest time until the adoption of Dodd-Frank, when it was given the lion's share of jurisdiction over most derivatives. So under Dodd-Frank, approximately 90% of all derivatives fall under the scope of the CFTC, with the SEC exercising the remaining 10 or so percent over products that would be characterized as security-based swaps, much smaller market. It's important to note that with one notable exception, the CFTC has not exercised jurisdiction. In fact, it's statutorily precluded from doing so over the cash or spot commodities markets. The one exception is the Commodity Exchange Act, Section 2C, 2D, and it requires a satisfaction of 3 criteria. So all of them have to be true. So you have to have the purchase by a retail investor of a commodity, so retail investor. Number 2, that purchase has to be on a leveraged, margined, or otherwise financed basis, 2. And the retail investor cannot be able to take actual delivery of the commodity within 28 days of the execution of the transaction. So if all 3 of these criteria are true, then the regulators, the CFTC, would treat this as a de facto future. And so you might say, well, what does that mean? Why is that relevant? If it's treated as a de facto future, it is subject to the Commodity Exchange Act rules and regulations with respect not only to the intermediaries involved in the sale of the product, which then might be considered to be futures commission merchants and therefore subject to registration with the CFTC through its self-regulatory organization, the National Futures Association, or the platform itself might be viewed to be an unregistered board of trade subject to regulation as a designated contract market or a swap execution facility, of which more a little bit later on. Next slide, please. Oh, there we go. Thank you. So the CFTC in recent years has taken the position that certain types of virtual currencies are commodities under the Commodity Exchange Act. And the reasoning in Monex, which was continued in subsequent cases, is that if the digital asset in question functions in the same way as fiat currency would, it really is a proxy for fiat currency. It's therefore a virtual currency, and it's therefore a commodity. And so specifically in a couple of cases, the CFTC has singled out Bitcoin and Ethereum as being virtual currencies. In 2016, the CFTC brought its first ever enforcement action against a platform, also known as a board of trade, or more colloquially as an exchange, that offered virtual currency transactions to, and here are the magic words again, retail customers on a leveraged, margined, or finance basis. I didn't mention it here, but they couldn't take delivery in that case within 28 days. And so as a practical matter, that platform should have been registered as a designated contract market or a swap execution facility. Next slide, please. So the CFTC, in response to market confusion, offered some guidance as to what constitutes actual delivery in the context of virtual currencies. The concept had existed before, but with respect to generally physical settlement of commodities. But with actual delivery, because that is a term of art in the crypto space, the CFTC took the time, and I would commend it to you by clicking on the site. It was published on June 24th of 2020, so almost 3 years old, describing actual delivery in the context of digital currencies. So what you're seeing between what I'm saying and what Walter said previously is that there's a tension in the regulatory landscape. On the one hand, the SEC regulates securities, the CFTC regulates commodities, although with one exception, not in the spot and cash markets. So the debate at the end of the day is who's going to have oversight over this asset class. Next slide, please. And the agencies, the commissions have recognized that there are differing views that they have to resolve regarding regulation of digital assets. This is not a new thing. And the CFTC has asked Congress specifically to clearly define the difference between what's a commodity and what constitutes a security, apropos of what Walter was talking about earlier in his presentation. So I'm going to mention a few of the recent legislative initiatives. There are a couple more. But in particular, I wanted to point out the Responsible Financial Innovation Act that was introduced in the Senate in June of last year, so about a year ago, and the Digital Commodities Consumer Protection Act of 22, which was introduced also in the Senate a couple of months later. Both of those would have created a regulatory framework that would more clearly define, at least in the view of the lawmakers, the appropriate jurisdictional boundaries. And they also offered enhanced consumer protections and other transparency requirements, but they alas expired at the end of last year, pretty much coterminous with the end of the last Congress. Both of these bills would have given the CFTC more extensive jurisdiction over digital assets, including in the spot markets, not just in the context of the de facto futures issue that we talked about, but in the spot and cash markets generally. I should also mention the Digital Asset Anti-Money Laundering Act, which was introduced in December of 22, so just 6 months ago, by Senator Elizabeth Warren. This bill, had it been adopted, would have required market participants to apply the standard Know Your Customer rules to digital asset participants. And by participants, that would include the wallet providers, but also the miners. The bill would have also provided restrictions, prohibited financial institutions from transacting with digital assets mixers. Those are the entities, the platforms, the websites that would obscure the origin of funds as well as other information involved in a digital currency transaction. That bill directed both the CFTC and the SEC to establish risk-focused examinations and also to review the adequacy of anti-money laundering programs and reporting obligations imposed on the players in that marketplace. But that too expired with the last Congress. Next slide. So the CFTC has taken the view as follows, that crypto platforms already combine spot trading of crypto as well as derivatives on crypto. And their argument is that once there is a regulatory framework out there, it should give it, the CFTC, authority over spot trading as well as derivatives. Recall that they have 90% of the derivatives markets already. The House recently, in the last couple of weeks, just released a discussion draft that is designed to theoretically resolve uncertainty as to which commission would have jurisdiction over the digital asset markets. It too would divide oversight between the CFTC and the SEC, but as in the prior initiatives, the ones that expired at the end of the last congressional session, it would give the lion's share of oversight to the CFTC. To throw potentially Chair Gensler of the SEC a bone, it calls for joint rulemaking between the two commissions. But in terms of, and people have asked me, what is the likelihood of success? Does this initiative have legs? It certainly will be discussed. How far it will get, especially in light of the fact that earlier precedents have not gotten that far, that remains to be seen. I think I'd be remiss if I didn't mention some of the state initiatives. In particular in New York, where I practice, Attorney General Letitia James very recently, in the last week, introduced the Crypto Regulation, Protection, Transparency, and Oversight Act, which has been acronymized as the Crypto Act. And if that is enacted, it would probably represent the most sweeping legislation on a statewide basis in the United States. It would require the registration of crypto brokers, marketplaces, platforms, investment advisors, and issuers doing business in New York with the New York Department of Financial Services. Quite sweeping. Can we go to the next slide, please? So looking in 2023 and beyond, the CFTC is trying to get ahead of this to the extent possible, and it's proposed a set of recommendations for Congress regarding this to be implemented regulatory framework. So the CFTC has said, look, as a result of the adoption of Dodd-Frank, and even earlier in the case of designated contract markets, we've got the architecture, the technology in place with respect to the platforms on which these products are traded. Just for those of you who may not know, a designated contract market is generally a board of trade for the trading of futures, options on futures, and options. Retail investors can access a designated contract market, whereas a swap execution facility, that was adopted as part of Dodd-Frank, it's accessible only by eligible contract participants, which broadly defined would be a sophisticated investor, one who, by virtue of its status or its assets or both, is deemed to be suitable for investing in swaps. The CFTC says, we have this architecture in place, so let's just expand it a bit to include digital currencies. And in addition, we also have intermediaries that are subject to registration, and we've got rules with respect to them. Let's just expand that to include a category of digital currency brokers under the architecture that we've created for futures commission merchants. So they're trying to be proactive about it. And their view is, look, there's been a lot of regulatory fragmentation. We understand that it's characterized this marketplace. It's not great for anybody. But so let's put oversight of the spot digital assets in the hands of a single agency. And of course, let it be us, let it be the CFTC. As I noted previously, they would require a registration requirement for the digital currency exchanges. And then finally, they're seeking regulatory power to compel participants in the digital asset space to have some kind of a mechanism for segregating and protecting customer funds. They also have to prove that they're maintaining sufficient capital to operate, and they also have to provide public disclosures backed by independent accounting. If you go into the criteria required of designated contract markets and swap execution facilities, you'll see that those requirements already exist for those types of entities. So if we could go to the next slide, please. So in summary, I had mentioned 3 of the bills that were introduced in 22. There were at least 5, and none of them got even close to passage. They expired at the end of the congressional term. I should point out that there are supporters and detractors of digital assets on both sides of the aisle and in both chambers of Congress. So you've got the House Financial Services Committee Chair, Patrick McHenry, who's been a vocal crypto supporter. On the other hand, you have Senate Banking Committee Chair Sherrod Brown and also Senator Elizabeth Warren, who have been real detractors in the area of crypto, and as such have proposed more stringent regulation. Debbie Stabenow has tried to intermediate this gridlock. She's the Senate Agriculture Committee Chair, but she's so far been unable to resolve the turf battle between the CFTC and the SEC. And so what we're likely to see, at least in the near future, would be the continuation of gridlock. The other area, and Walter and I have talked mostly about the regulations, the laws and regulations that are there, but there is also the concept of regulation by enforcement. And so I think we need to launch now into a discussion about the potential impact of judicial decisions in the digital asset space. And so this is a perfect time to turn matters over to David.
All right, hi everyone. Well, next slide, please. Now I have the distinct honor of presenting the world's least imaginative CLE code word in history. As we mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word, which you can see, crypto, into the Q&A section of your screen. Please make sure to hit the send button so it registers. But if you do that, you should be good to go on your CLE credit, which is all important. All right, next slide, please. So before I dive in here, I just want to say another word following up on Alice's last point and Walter's as well. You've been hearing about the sort of regulatory framework. And really, there's what's going on is at a very high level is a discussion between the regulatory agencies on one hand, that would be primarily the SEC and the CFTC, Congress, where there's a lot of talk and so far no action, and more the courts, and not to mention, of course, the crypto industry, which is extremely vocal on all of these issues. And you can really think of it as kind of a debate and a passing of the ball back and forth. And so far, what there's really has been is a void on the regulatory side, which the SEC primarily, but also the CFTC and DOJ have filled by bringing actions using their enforcement powers or criminal powers in the case of DOJ to fill that void by trying to stake out legal positions through the enforcement process. And a lot of the actions have been settled, which means that courts really don't weigh in on them. And as we'll see, though, there have been a number of judicial decisions and more big ones are expected, both, I think, in the months ahead and then also in the years ahead. And I think an interesting question is, will there come a point where the judicial decisions, whichever way they go, kickstart a legislative process or advance the legislative process where it might forge some sort of consensus where none exists that some legislative reaction to what the judges have done is needed, and perhaps ultimately provide some kind of pathway of consensus to get clarity that the industry has been clamoring for a long time. But we're kind of in the middle of that morass right now, where all of these voices are speaking. There's more speaking than hearing and listening. And so far, it's been a lot of enforcement actions, which is not really, in anyone's view, the best way to provide regulatory guidance and stability to a very large industry where a lot of Americans and others around the world have invested significant assets and resources. So a quick look at some of the data. We don't really have a lot of 2023 data yet, but looking back at 2022, which was a big year, SEC brought 30 crypto-related actions, big increase over the prior year. They added over, I think, 20 people to their unit in the enforcement division devoted exclusively to crypto. And I think they're all overworked as it is because there's so many cases that they are bringing. They brought 100, actually now more than 127 since 2013. And the bulk of those have been in the last couple of years. Humongous penalties have been assessed, more are being sought. Broadly speaking, the cases allege both fraud and then the more technical registration regulatory violations. 2023, the SEC has really just doubled down. And Walter mentioned actions against exchanges, and those really are the latest and most extreme step in the SEC's enforcement program that's been going on now for many years. And these have been much in the news since December of last year. 4 different exchanges, crypto exchanges, have been sued both by the SEC and in some cases the CFTC. And in the case of FTX executives, Samuel Bankman-Fried and others, criminal charges as well. So the exchanges are in many ways the current focus, and they are the potentially most significant from an industry standpoint because the largest amount of purchases and sales, transactions in crypto in the industry are done over exchanges. And these actions, if they are successful, have the potential to shut down all of the exchanges in the US, which would effectively drive the industry outside of the US to other countries that have more forgiving and tolerant regulatory regimes involving crypto. So these actions in some ways are going to be the most important. And because there is so much at stake, and because these exchanges have been profitable, they have the resources to hire top law firms, put the SEC and the CFTC and DOJ to their proof, and take the cases to the limit, which will involve motion practice, judicial decisions, jury trials potentially, and finally get some of these issues, I think, up to the appellate level, where appellate courts will be able to weigh in a more definitive way than the sort of scattering of district court and magistrate judge decisions that we've seen over the last few years. In some ways, the Coinbase case is the most significant for potentially drawing some lines in this area. Coinbase of all, at least according to the allegations that have been made, is the exchange that has tried the hardest to be compliant. It went public in 2019, went through that process, and the SEC didn't say, hey, we can't let you go public because what you're doing is illegal. The SEC let them go public. The Coinbase has made efforts to try to register. They have had a lot of meetings. They even filed a petition with the SEC to require the SEC to issue a rulemaking. And that petition is now in the courts. And just yesterday, the SEC responded to an order from the DC Circuit. The DC Circuit said, hey, SEC, what's the status of your rulemaking? We hear Chairman Gensler saying different things about the need for regulation or legislation. Are you going to issue rules, and when? And the SEC responded, said, well, we're thinking about it, and maybe we'll pass some new rules in 4 months, and maybe not. So they were careful to maintain their position that the court really can't make them do rulemaking, but they at least did signal that 4 months might be a potential time frame for them to state definitively one way or the other whether they plan to propose rules in the crypto area. I guess I wouldn't bet too much on that. So Coinbase, there's a lot of interest in that action in particular. It doesn't have fraud allegations. And in the Binance allegations that you may have seen, there's a lot of allegations that behind the scenes, Binance executives were making very strong statements that they won't be regulated. They structured a US arm of the exchange to try to ring fence and limit their exposure to US laws. They knew they were taking regulatory risk, and at least according to the allegations, are taking sort of a more combative approach towards regulation. Coinbase is taking a different approach, which makes it in some ways the purest test for what is the scope of Howey, what is the scope of the current SEC regulatory regime, and does it shut down all trading on exchanges in crypto? Yesterday, in the Binance case, there was a hearing before Judge Berman on the SEC's motion to freeze Binance's assets, which of course would completely shut down the exchange, at least in the US. And Binance pointed out to the court, we're only a few days into this case. It seems inappropriate for the court to basically issue a death knell to the business before the parties have even litigated the underlying issues. And Judge Berman had a lot of sympathy to that point of view and went out of her way, I think, to make a comment casting doubt on the regulation by enforcement approach that the SEC has taken in crypto. So maybe it's the beginning of some judicial pushback on the SEC's approach, which so far has generally been successful in the cases that have been litigated before the courts. But it may be that they've now, pushed their position on the scope of Howey to sort of its logical limit to such an extreme that, courts may be thinking about how do we draw some lines, how do we make some limits here on the SEC's authority. And so that suggests that there's going to be some interesting time ahead in the litigation of these enforcement actions. So on that, let's turn to the next slide, and which touches on that. And and Walter hit these points pretty well. In terms of applying the Howey test, the SEC started out with ICOs, and courts had a pretty easy time saying that ICOs were very similar to IPOs, and found that the SEC's arguments generally upheld them, that Howey applied to those tokens. The SEC last year broadened their approach to suing some DeFi platforms involved various crypto lending offerings, and those cases were mostly settled, and the SEC prevailed in that way. The SEC brought a crypto insider trading case, and which has been resulted in a couple of settlements and guilty pleas on the criminal side. And both the insider trading and the crypto exchanges sort of pose the legal question: is the SEC's Howey analysis and attempt to apply it sort of across the board in the crypto regime, does it apply to secondary trading as well as initial offerings or initial sales or creations of tokens, where the purchasers are they're interacting with software, but the software was created by the developers, by the creators of the tokens, looks a little maybe closer to a securities offering by a company. Walter mentioned Tesla and Microsoft, traditional companies issuing stock. Once you get to exchanges and secondary trading, particularly if time has gone by since the creation of the tokens, those initial founders, creators are not on the scene. And it does pose a potentially different question for courts as to whether all of these tokens are or should be considered securities under the Howey test. So all that's going to be litigated. Let's go to the next slide. So as I mentioned, for now quite a few years, the relatively few cases where the defendants had the means and the will to litigate, courts have generally upheld the SEC's application of the Howey test to digital assets and concluded that they are investment contracts, which, as Walter pointed out, under the definitions in the securities statutes, are a type of security. So the big question that a lot of people have is, well, will there be a limit there? And so far, there's really one decision out there. And that came last year. where a court did hold, and the SEC was not a party to the case. It was a private action brought by the purchaser of a token called a hashlet, and claimed that they had been defrauded, and claimed and brought the case under the securities laws. The case actually went to a jury, and the jury found that none of the crypto assets were securities under Howey, including hashlets. And the jury verdict, while it's interesting, doesn't have a lot of precedential value, but the defendants in that case, or the plaintiffs in that case, brought a motion asking the judge to essentially overturn the jury verdict, and the judge upheld it and actually put out a written decision saying that hashlets did not satisfy Howey, and they referenced the common enterprise requirement that Walter mentioned earlier, and said that in that case, this involved when you buy a hashlet, you're essentially putting your purchase price towards the mining of additional hashlets, and you can identify which server and which tokens would be mined. So the defendants argued, hey, so you're not pooling assets, you're not relying on the expertise or the efforts of the developers who initially created the token. You, the purchaser, have control, and the judge upheld that and said that that is one example of a digital asset that is not a security. And I don't think there's been an appeal in that one, so that one is, I think, going to live on as a lone district court decision, but at least it is one decision. But more are expected. So let's go to the next slide. And I will say a few words about a case that's been discussed now for quite some time, the Ripple Labs case that's pending in the Southern District of New York. This one involves the question of whether a token called XRP is a security. This one, there are several defendants, both Ripple Labs and some of the executives or former executives of Ripple Labs. And this one is one where they've all hired top-tier law firms. They're litigating intensively. There's been extensive motion practice, and there is a summary judgment motion that has now been pending for some time before Judge Torres in the Southern District. And a lot of people are eagerly awaiting her decision. And the reason that this case in particular is worth watching is that XRP was created back in 2013, so 10 years ago. And I think 8 or 9 years before the SEC got around to bringing the case. And because it was created so long ago, even if the SEC wanted to say, well, the initial offering of those tokens violated Howey, the argument on the defense side is the trading of those tokens has now been completely decentralized. That it has nothing to do with the original creators of the token. These are now tokens that have utility on their own, that are being bought and sold in the marketplace. And Howey, for a lot of reasons, should have no application to XRP. There were amicus briefs filed by leading industry participants. It's about as litigated as an issue could be. So the question is, when will Judge Torres decide this? And will she put another marker down limiting the SEC's jurisdiction in this area? As we're getting towards the end of the time, I'm going to talk about one more case, if we can flip to the next slide. So we here at Denton's are particularly excited about an oral argument that's happening tomorrow in a case before Judge Rakoff, also in the Southern District of New York, where we are representing Terraform Labs and its founder, Do Kwon, in an action that the SEC brought earlier this year, alleging both registration violations and fraud involving 4 different digital assets, one of which is called US Terra, which was a stable coin. And as many of you may know, a stable coin is designed from the outset to be pegged to the value of a fiat currency, in this case, the US dollar. And US Terra was a so-called algorithmic stablecoin where that pegging to the dollar was designed to take place through the buying and selling of a companion token called the Luna, where if the peg moved in one direction, there'd be an incentive for people to buy or sell or trade, exchange Lunas for US Terra, and that trading would naturally push the Terra back towards its peg of $1 US. And as it happened 2 years ago, the Terra UST lost its peg, and then it was restored. Then last year it lost its peg, and the market was not able to restore the peg. And the SEC brought that case earlier this year. And the defendants have moved to dismiss on a lot of grounds. And I've listed them here on this slide, and a lot of them are key issues to a lot of the crypto litigation. Lack of personal jurisdiction. The basic argument there is these tokens were made available globally. The US and people in the US bought them, but it was not specifically targeted at the US. So do US courts have jurisdiction over tokens that were made available globally and not targeted at the US? Does the SEC have authority in this area? There's a doctrine called the Major Questions Doctrine, which says that when Congress wants to delegate to regulatory agencies the authority to regulate an industry, an area, it needs to do so clearly. And here, as Walter pointed out earlier in the presentation, the definition of a security certainly doesn't include anything like a crypto asset. And so the question is, was that enough of a delegation to justify what the SEC is doing in all these cases? So as our time winds to an end, I'm going to just thank everyone for joining our session. I'm going to turn it over to Jay Maples, a shareholder in our firm's Birmingham, Alabama office, to begin the second hour of the CLE program. And don't hesitate to reach out to any of the panelists if you have questions about any of the issues that we've talked about. So thanks very much.
Thank you.
All right, welcome everybody. This is Jay Maples. Thanks for an excellent presentation to precede us. I listened to part of it while I was preparing. It was great as a holder of a lot of some crypto, mainly Bitcoin. I wanted to know actually, when are you going to tell me the market's going back up? That's what I really wanted to know. But all kidding aside, welcome to the presentation. This is Essentials of Private Aviation. I'm going to be joined by my colleague in Indianapolis, John McCauley. My name's Jay Maples. I'm in Birmingham, Alabama. I've been practicing, it's hard to believe, 22 years now. And as part of my background, I was a CPA. I did for a small company. Then I went to a public company that actually ended up flying on several of their jets before I went to law school. And coincidentally, I went to law school in Alabama. I went to NYU to get a master's of law in tax. And I've been with what was the old sorority and permit firm prior to joining Denton's for now 22 years. And in my second year of practice, I was a normal corporate tax guy doing just, M&A work and broad tax work. And somebody said, hey, we got somebody that left, they're working on airplane transactions. Do you know anything about airplanes? I said, I do. And the only thing I really knew about them was I'd flown on them. And so 20 years later, it's now about a third of my practice is mainly buying and selling airplanes. The other 2/3 is general corporate M&A, tax controversy, and a lot of employee benefits sprinkled in. I'm gonna flip it over to John, let him introduce himself, and then we'll proceed to our program.
Thanks, Jay. My name is John McCauley. I'm a partner in Indianapolis. As a way of background, I was a Navy pilot for 12 years. Got about 1,000 hours of flight time, 301 carrier landings. That's always good when those add up, typically. I also was an aviation safety officer, have a lot of experience, obviously, around airplanes with the FAA, representing clients before the FAA, also working on the operational side of aircraft sales, that type of thing. And then most of my practice these days is in the area of cybersecurity, data privacy, and we've had quite a few cyber aviation incidents recently that I can share with you as we go through.
Great, thanks, John. Hey, Brian, if you could advance a couple of slides. Let's go a couple more. We'll stop on this one. Yeah, I like this quote. Aviation in itself is not inherently dangerous, but to an even greater degree than the sea is terribly unforgiving, meaning carelessness, incapacity, or neglect. And obviously that's probably mainly related to what I would consider the flight safety, which John will talk about. But it's also unforgiving when it comes to the other thorny issues of tax and deductions and things of that nature that can, if you don't think about it on the front end, and something comes up later, an IRS audit or SEC investigation if you're publicly traded, and then you got to explain something in hindsight, it becomes, very unforgiving. On the safety side, I try to take a holistic view of aircraft transactions as what I view as a corporate advisor of an organization or an entity, and I've done M&A work for 20 plus years now. So I see companies either cradle to grave or almost cradle to grave. When I say grave, I don't mean bad. I mean in that, hey, a company started and maybe I started it 20 years ago and they sell, and some have a defined exit strategy. Others we worked on for 30 years and ultimately the family sells out. And part of that, and I will highlight one example of that later on, but part of that is taking a holistic view to how do you acquire the aircraft? What entity do you put in? How do you comply with the FAA? How do you make sure your tax efficiencies work? How do you document everything? And so it's not just a one trick kind of pony where, hey, I'm buying an airplane and I don't really, I've got a myopic view and I don't really look at anything else. I think it's very important to at least have somebody on a team that looks at is quarterbacking a corporate structure. And that sometimes is me, and sometimes it's some of my partners that are the main client attorney. But Brian, if you can advance to the next slide. So in the part one of this, spoke with my partner Ronald Levin. We covered quite a bit of tax stuff, but we really hit on acquisitions and dispositions. I view these as sort of like buying a company, except you're just buying a very expensive movable asset. It always surprises me when a lot of business owners, they will, if you're buying a $10 million business, they'll hire accountants and lawyers and you'll diligence it to death and you'll have $300,000 or $400,000 in legal and accounting fees before you buy the business. And then I'll come up with that same business owner will have a $10 million purchase contract for a plane that he says, oh, hey, I already signed this. Are there any problems with this? Or, oh, we already bought it and we put it in this structure and no, we didn't talk to anybody. And now we've got an FAA type issue. So that part of the acquisition and disposition is thinking through things and not treating it more like the acquisition of a business where you got to think through it. Ownership structures. we talked about in part one, those were anything from, it's not really ownership, but the first step a lot of times is, hey, you'll charter a plane. You dip your toe in the water. You move from commercial flight to we charter one. And then we look at, okay, well, maybe we want a fractional interest through NetJets or FlexJet or one of those companies. Then maybe a share ownership. Maybe I don't have enough use. I want to share it. John and I want to buy a plane for our respective businesses. We form an LLC. We put the jet in there and then we lease it to each other. Or maybe I've got enough business to own a jet or multiple jets inside my normal operating company, call it OpCo, and you just buy the jet through the operating company. Now, the other thing we talked about, FAA compliance, the big one I hit on, John will hit on some other stuff later, was the flight department trap. You know, most lawyers and accountants always come up and they want to put everything in a special purpose entity. That's great, but the FAA has a different view of special purpose entities than the IRS and other taxing authorities. The FAA doesn't like them. They say a special purpose entity, unless it has a charter certificate, a charter license, which it wouldn't if it's a special purpose entity, you have to lease that plane to either an individual or somebody who holds a charter certificate, or to an operating company where the use of the plane is incidental to the business of the company. We won't rehash all that. That was kind of part one. You can listen to it on YouTube. And then I'm going to hit a few more federal and state tax issues over the next few minutes. Brian, if you want to advance to the next, and then one more. All right, so we're going to kind of go over some tax issues that really didn't get fleshed out fully in the first part, and obviously in my part it's going to be about 25 or 30 minutes. We're not going to do a super deep dive. But again, I think if you take away anything from my part of this presentation, it's going to be, you need to take a holistic view of how the aircraft is structured within the corporate organization. Obviously, we have a handful of clients that may have a jet that's their own personal jet, and they're not worried about business deductions, but 98 or 9% of the ones I work on are primarily business use, and you want to make sure that not only the acquisition of the aircraft, the depreciation is deductible, but all the other expenses, the fuel, the pilots, everything is deductible. So a threshold issue, a gateway to that is, well, do you have a trader business? And under Section 162, you certainly, that's the main code section. You got 212, which is the investment type stuff. I won't go back into all that. The key to it is substantiation on the front end. And I would add the other key is to involve your accountants on the front end, because ultimately, usually, the accountants are the ones signing the return. And so if you do something and then tell them about it later on, then my phone rings in February or March and says, hey, we just found out, company XYZ bought an airplane at the end of the year and didn't tell us about it, and they didn't document anything, and we've got to take this return position. They're wanting the bonus depreciation, and we don't feel comfortable with that. And so the substantiation is important. The IRS is attacking the reasonableness of planes now. They used to really not kind of poke into that area, but you have to look at it on a spectrum of, okay, let's say I've got a business and it operates only in one city. Well, do you really have any need to travel anywhere? Probably not. Maybe it's an occasional trip for a business seminar, but you can take a commercial aircraft to where seminars are usually located, Hawaii, Las Vegas, somewhere like that. So you really have to document on the front end, hey, why do we need a jet? We need a jet because we have 5 plants and none of them are located near a major airport. And so it's reasonable to buy a jet. It's also, well, what size jet are you buying? If you're buying a 6-seater Cessna Citation versus a 20-seater Gulfstream G7, okay, well, you've got businesses in southeast of the United States. Why do you need a global jet for that with 20-seater? We've got our records here, and the IRS will say, we got records here. We show that the only people that flew on that jet were your executive team. It's for 3 people. And, so you say, okay, well, it's the size of the jet. It's where are you going? We'll talk about a commuting expense, commuting deduction disallowance later, but that also kind of ties into the holistic of, okay, if you've got maybe the executive is in, by the easy one is Long Island, and he's flying a helicopter into his office every day in Manhattan, well, that's essentially commuting. And there's a disallowance rule for that. Now, commuting can, and I'll talk about this kind of at the end, commuting can be longer than that. We had a client that was flying from New York to Utah, and Utah was really his primary location. And we were concerned about that being commuting. Ultimately, this kind of, I'm gonna hit on this and we'll move to depreciation. The lender management was a family office case, which said, okay, can a family office be a trader business? And the answer to that was yes, if it really is legitimate. Obviously, if you sell your company, you get $1 billion and you park it all in, an ETF, and you don't do anything, well, that's not going to be a trader business. But if you have multiple businesses, maybe you sold out one large business and you got multiple businesses, and your job is kind of managing those businesses, almost like a private equity hedge fund, where you end up with a whole bunch of stuff. Well, then, yeah, you can justify having a jet of a certain size that goes and manages those companies. And this is where I would also say the cradle to grave is important. Where I'll talk about at the very end, we'll talk about a situation where you had a jet that was owned by the operating company, client was selling it, and they wanted the jet out of the operating company. Well, if they had thought about it on the front end, they may have put that jet maybe either through a special purpose entity or put it into essentially created the family office on the front end as a management company that managed the various businesses. And then when they sold one of those entities out of that group, the jet didn't go with that group and cause a problem of how do we get the jet out of that group? They already would have the jet kind of outside of that group. And then when you sell that operating company, you still have a management company in place. So again, the holistic approach is very important in the transactional scenario. Brian, if you want to flip to the next slide. Depreciation obviously is upfront, can be the lion's share of the expense of purchasing a jet. Bonus depreciation was 100% up until this year. It's dropped to 80%. I think the next year it drops 60, 40, 20, and then goes away. Ultimately, I can't make any predictions, but the airplane lobby is very strong. It's obviously made up of large corporations and very wealthy people on all sides of the political spectrum. And with the elimination of the like-kind exchange, bonus depreciation essentially replaced that. And so I would suspect that you'll see bonus depreciation reappear at some point before it phases completely out. But you do need, this is another example of involving your accountants on the front end, because as lawyers, a lot of times we don't have privy to all this stuff. You want to say, okay, do you really want bonus depreciation? If you've got a bunch of losses already and maybe you're losing money now, but you're going to make money in the future, maybe you want to do it straight line. Maybe you want to do a makers, a modified accelerated depreciation. Straight line and maker. I think makers is 5 years. Straight line is, I think, 6 or 7 for private. I think it might be 12 for scheduled carriers. I don't do a lot of scheduled carrier work, but so there may be reasons why you don't want it all to be bonus up front. Maybe you want to have straight line for certain reasons. If you move into makers and straight line, then you have to look at the complex rules regarding when did you place it in service? Is it a mid-year placement in service, or is it, if it's in the last quarter, you only get partial depreciation for that year, essentially. Another depreciation issue that comes up is frequently clients, especially when it was 100% bonus depreciation, would start scrambling towards year end saying, man, I got $10 million taxable income this year. You know what I want to do? I'm going to buy $10 million worth of assets, and one of which could be a jet or something else expensive. And then they find a jet, and closing is set for near the last day of the year. And one of the requirements for the depreciation is, well, it has to be placed in service. And then you also have to look at the qualified business use of, well, are they business trips? And so if you do it too close to the end of the year, you run into, okay, can we get it actually in service by the end of the year? And so again, forethought on the front end versus a knee-jerk reaction towards the back end of the year, where now you're scrambling to buy a jet to get bonus depreciation, and you want to dot the I's and cross the T's to make sure, yes, we are going to get the bonus depreciation by actually putting it in service, making sure, documenting the business use of the aircraft, making sure that for at least that year, it's 100% business use, so that you get 100% of the bonus depreciation. There's also qualified business use issues that creep up. If you have non-qualified business use, then so you have to have at least 50%, but there are special rules that the aircraft industry got negotiated into those regulations that basically said, okay, if the qualified business use is at least 25%, we'll disregard the non-qualified business use, which is personal use by a 5% owner, and then other type of specified persons that are enumerated. And so that's an important thing to watch out for. It's easy to navigate if you put forethought into it and track it in real time, so that you don't get caught flat-footed, or worst case, you've actually done it, and now again, it's March and the accountants are calling, me and saying, oh, wait a second, we look back at the logs, and maybe some of the stuff they were flying down to the beach house. And so you don't want any beach trips, when you buy the plane. Couple other depreciation points that I wanted to hit. Sometimes state depreciation does not have bonus depreciation. I know for a fact that New York does not. And so you want to make sure that, hey, if you're in a high tax state like New York, you've got to look at, well, am I going, what is the state level impact on depreciation? And then when you sell an aircraft, you're going to have recapture. Now, normally, so if you buy a $10 million aircraft, you fly it for several years, and you sell it for $5 million. It's fully depreciated. You're gonna have $5 million of recapture. But if you turn around and buy an aircraft at $5 million or more, and let's presume bonus depreciation goes back to 100%, you essentially offset any of that recapture. But if you have a situation where a client is winding down their business activities, maybe to sell the company, and they're retiring, recapture needs to be thought through and planned for, so that there's no ugly surprise of, oh, we just sold our $5 million jet, and now we've got $5 million of income, and we don't have any way to offset that income. Brian, you can flip to the next slide. Passive activity loss limitations usually come up, and it is I will admit, even as a tax lawyer, I hate the passive activity loss rules, and I'm not an expert on them. I have experts here in the firm, and I would call them, but I know enough to recognize them. I know how to get around them, but they are a thorny a thorny set of rules if anybody here has ever dealt with them. But normally these would arise when you have a special purpose entity that is, you've got OpCo that's your operating company, you form a special purpose entity, and then you lease the plane to the operating company to comply or to avoid violating what's called the flight department trap, which is the rule we talked about at the beginning, which says you can't have a special purpose entity that operates a plane that doesn't have a charter certificate. So you buy the plane and you lease it, you've rented it now to OpCo. Now, rental activities are per se passive activities. And the passive activity loss rules in general say that passive losses can only offset passive gains. And unless you have material participation, then they become active. Well, in the rental activities there are some special rules for rental for real property, but it's very difficult to get active. But you can get around those rules by grouping election. And so normally this doesn't present a problem where you've got one OpCo, one operating company with a special purpose entity below it, and you've got one user lessee of the plane, and it's the one that uses it. Again, from a holistic view, you don't achieve a lot of liability protection by using a special purpose entity with an aircraft because you have to lease it up to an operating company. It can make sense to have the operating company be the owner of the airplane in the right set of circumstances. Or it can make sense to have an overall kind of family office management company be, the owner of the plane, so that you don't have to worry about these passive activity loss rules. But again, this is also one of those, as lawyers, a lot of times we don't get involved in all the passive activity losses. And also a lot of my clients, I may be dealing with OpCo, but I'm also not dealing with, hey, the family owns all these other type businesses, and maybe I'm working on just 1/4 of their stuff, and they've got other lawyers working on everything. And the only real quarterback the family might have is the accountant. And so it's important to involve the accountants on the front end of the structuring of the acquisition to make sure you don't run afoul of or that you can comply and make sure the losses are deductible. I won't talk a lot of the excess business loss limitation is something that came in with the Tax Cut and Jobs Act, and it basically said we're going to disallow certain losses if they exceed income by, I believe it's $250,000. The at-risk loss limitations also rarely kick in, but it's something to consider. It would come in mainly if you had a real estate business. I actually struggle to find an example, and those rules basically are when you have non-recourse debt. They usually show up in the real estate world, and then the IRS would say, okay, you don't get a loss because you don't have any money really at risk. It would be a rare case, but again, it's one of those things to have on the checklist to make sure the accountants are in the loop on that. Brian, you will flip to the next slide. Yeah, personal use. There's one other thing, and I may not have a slide in here, but I did want to mention, because I'm going to talk about it at the end. There's also a hobby loss. So if you don't have a real trade or business, the IRS might attack it as a hobby, and hobby losses under Section 183 are deductible only to the extent of income, and unless you show a profit in 3 of the 5 years for anything other than horses, and horses are 2 of 7, then it can be a hobby, and you would generally have a loss disallowance because you're not going to show a profit. And so that kind of relates into a big kind of component of the hobby loss. Well, there's going to be a lot of personal use aspect to that. Now, the personal use of the airplane. So let's say you've got OpCo that owns an airplane. It's got a legitimate business, and most of it's deductible. But let's say the husband or wife is taking a business trip with some executives, and they're going to visit a facility, and perhaps one of the spouses wants to tag along. and the spouse can tag along. You can't charge the executive or the spouse for that trip, otherwise you violate, FAA compensation, flight compensation for hire rules. But the amount of the flight would be deductible to the corporation, but they would have to include in the income of the executive basically phantom income for the benefit to the spouse coming along on the trip. And the ways to handle that, there's a complex set of rules. Or the normal way is basically you're charging them for the tickets, fair market value or standard industry fare level. There's also other ways you could lease the plane to the executive, basically kind of make the executive charter that plane. Brian, let's flip to the next slide. Because I really want to hit kind of these two. These can easily rear their head, which is this is going to be the commuting and then the business entertainment disallowance. Commuting and business entertainment, they both came in under the Tax Cut and Jobs Act, and it basically said, okay, we disallow commuting, and the statute says no deduction shall be allowed under a chapter for any expense incurred for providing any transportation or any payment or reimbursement to an employee, critical, an employee of the taxpayer in connection with travel between the employee's residence and place of employment. So if you have a C Corp and you've got the executive who's an employee, then and he's flying from, say, the Hamptons to New York, well, that's obviously commuting, or it could be commuting, most likely would be. There's an exception that says, okay, but if it's ensuring the safety. And so one thing you can do, again, front end planning, if you think commuting is going to be an issue, you want to have a safety specialist conduct a safety study so that you've got something in the file where if it's ever challenged, say, hey, listen, it is unsafe for our executives to travel from their house to wherever they're going. And that may not be the Hamptons, but think, a place that might be dangerous. But a critical thing is they use the statute says for employees. Well, in the partnership world and in the S Corp world, there's a specific regulation or a specific statute that says partners are not employees for purposes of the Internal Revenue Code. And so that rears its head in a lot of employee benefit stuff, but it also comes up here, and there's no guidance yet of, okay, well, if you've got an S Corp where the owners of 2% or more owners treated as a partner, does this statute apply to them? Does it disallow theirs? What about directors? What about somebody that's got a Schedule C business? So it's an interesting thing. We don't have guidance on it at all. And then how do you treat it? Is it no expenses deductible? Only the amount that's included income is deductible. All expenses are deductible. How do you kind of treat this? And then Brian, flip to the next slide. Okay, we've got our code word. Let me read this to you. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word aircraft into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is aircraft. All right, Brian, you can advance to the next one. Business entertainment disallowance, kind of related to the commuting, with another Tax Cut and Jobs Act says, okay, if you're taking business trips, we're going to disallow it. And the test that applies is the primary purpose test. And so that means you look at not the primary purpose of the flight. And let's take a trip to, let's say you're a car dealer and you're going to SEMA in Las Vegas. And so you would say, well, the primary purpose of the trip isn't to go gamble. The primary purpose is to go to Las Vegas and attend SEMA, an industry event. And then you would look at, well, once we get on the ground, what expenses are deductible? And so you need to make sure that, okay, on the front end, you need to, again, it's document who went on the trip, who attended, why did they go, where did we go? And this kind of rears its head when you have a lot of clients that are taking business trips to the beach to go to their beach house, and they're wanting to say, well, it's we're taking people down there and it's whining and dining. Well, that's a tough thing to, especially in hindsight, you really want to think about that. Again, another time to involve the accountants. Brian, flip to the next slide, and I think I'm going to briefly hit this and then turn it over to John, and we'll wrap some of this up on the back end on some of this. There's kind of what's the ticket tax, which is a 7.5% on amounts paid for compensation. Generally, if an operating company owns a plane, this doesn't become an issue. If they hire a management company, it's not an issue. It can become an issue if you use a special purpose entity. Although there is some relief by the Tax Cut and Jobs Act and the regulations that say if you've got a lease that's more than 31 days, then that will be the lessee will be treated as the owner, and any payment for management services will not be treated as compensation subject to this. But this can get quite complex if you have a broad kind of org chart of different companies using things or using the jet. It's something you have to watch out for depending on who's making payments to the management company. The IRS has been pretty aggressive in the past, especially prior to 2017, which is why the aircraft industry got this exception in there, because the IRS was very aggressive at attacking things that the FAA did not consider commercial, but the IRS did, and they wanted to put a ticket tax on it. And it's one of those deals where if you never filed a tax return, there is no statute of limitations, so they could go back as far as they wanted, which creates a significant risk of penalties and interest. Brian, I think forward to the next slide, and I think John, it'll be you at this point. We can, if we have time, I'll hit some of the sales tax issues or state issues, which I think I already hit a couple of them. But forward to the next slide, and then John, I think it's over to you.
Great, thank you, Jay. Appreciate it. I know in the last session, there was some discussion about the difference between Part 135 operations under the FAA rules, and that's basically carriage for hire, right? So if you're paying to move people or move goods, they need to have a Part 135 certificate, as opposed to private folks who do nonprofit flights under Part 91. We talked a little bit about the flight department sort of issue or problem. Sometimes they call it a wet lease, but there are people who operate under Part 91, and there's quite a few of them out there who also will rent out their airplane, and that's a violation of Part 135. And the difference is 135 requires much higher level of training, certification, those types of things. But there is one rule that I wanted to share with you. Under Part 91, you can allow and charge someone to fly your airplane. They can take your aircraft on a trip, and you can charge them fuel, oil, and lubricants ×2. So you figure out what your fuel costs are, oil, and any other lubricants you use, and you double that, and you can charge someone that amount. Problem is, it's pretty carefully crafted by the FAA that it's never going to cost or cover the entire cost of the flight. When you figure in landing fees and your air crew and turnaround and all these other things, it ends up being much more than just twice the fuel, oil, and lubricants. And so where companies get in trouble is they charge more than fuel, oil, lubricants for the flight. And I'll give you an example. There's a company called Hinco Jet. They're out of Flint, Michigan. It's a big furniture company, and then they had Hinco Jet was their flight aviation arm, I guess you'd call it. The FAA investigators called it, instead of a Part 135 operation, they called it a Part 134.5 operation. Right, so they were operating like a 135 and renting out their airplanes, but they were charging more. And so it was significant because they fined Hinco Jet $3.3 million, which is a lot. but they found that they had operated over 850 flights. Now, I don't think the FAA has the manpower and the wherewithal to police this, very heavily. But when they do find somebody like Hinko, that there will be serious penalties for that. But in addition to that, the National Air Transportation Association, which is basically 135 operators, they've set up a illegal charter task force. And so what that basically means is if I'm a 135 operator on an airfield and I see somebody and I know they're operating on the same hangar or a different hangar, but they're charging for flights and charging under Part 91, they can report them to the task force, and then there'll be an investigation by the FAA. So most of the time when it comes to the attention of the FAA, it's not FAA investigators, it's actually other parties who are operating under 135, paying the expenses to operate under 135, but then seeing people do the same thing without